really appreciate my colleagues' thoughtful approach, and especially with the amendment to addressing the intention and what this board is trying to communicate as it relates to not criminalizing homelessness. But I think, in effect, that's what this case will do. The motion asks us to file a brief to the Supreme Court in support of the appeal, which, as we heard, the question before this Supreme Court, let us keep in mind, is a local government can make it a crime to involuntarily live outside and unsheltered, in other words, to be homeless, when adequate shelter is not available. And when I think about the conditions that we've just been experiencing in LA, could you imagine if you were getting fined for trying to protect yourself from the rain with a piece of cardboard, or trying to keep yourself warm with a blanket? That's some of what is behind this court decision, and I am clear that's not what my colleagues have said, but this court decision is really about these elements. The Ninth Circuit Court found that these laws to be unconstitutional, like their earlier decision in Martin v. Boise, which held that punishing homeless people for publicly camping would violate the Eighth Amendment's ban on cruel and unusual punishment. And I want to emphasize, if they did not have access to shelter elsewhere. If we are clear that the solution to homelessness is housing and services, and this case already provides for that. We know that currently there are already restrictions being put in place, even in the city of Los Angeles. The city has their 4118 policy, which is still permitted with Boise and Grant's past decisions. So the suggestion that cities or other local governments can't adopt or enforce policies without a reversal of the lower court ruling, just to me, is not true. Reversing the lower court, I believe, will further expand and empower such policies in ways that put vulnerable people even further at risk. I understand that there are some cities who are advocating for this, and there are cities who are also opposing. Mayor Bass recently expressed opposition, saying that a ruling could embolden those who want to criminalize homelessness. I don't believe that this court is likely to affirm expansion of rights for our most at-risk residents. So this amendment, I'm very clear, is well-intentioned, but I don't believe it's realistic with this Supreme Court to think that that's what the outcome will be. This case does not embody, in my opinion, care first policies. It doesn't protect our most vulnerable by requiring housing and services. It allows basically for cities to push people to say that they can't sleep here, not offering a solution for where they can sleep or where they can be served, but you just can't be here. And I don't hear that as care first, and I'm not saying that that's what my colleagues are saying, but to me, that's what these cases embody. And I think our county's Pathway Home Initiative, Mayor Bass's Inside Safe program have demonstrated some ways in which street encampments have been resolved without locking people up, without fining them. And so I think we already have the flexibility that exists should we be providing the services and shelter that are required to actually solve the crisis. So I see it a little bit differently, so I will be voting no on this item. Supervisor Solis.
Yes,